the host?
Oh, yeah, it was.
Oh, she did, okay.
All right, this is case number 22-180-325. This is Midland Credit Management versus Austere Mitchell. The matter is before the court. Still on for hearing. I do have the defendant's answer to the complaint in this matter. Record should reflect that this case arises out of complaint alleging damages in the amount of $2,722 resulting from a credit account. All right, your appearance for the plaintiff in this matter, please.
Certainly. Good morning, Your Honor. For the record, Stephanie Petway, P64543, appearing on behalf of the plaintiff.
All right, thank you, Ms. Petway, and good morning to you, ma'am. I'm looking now for last name Mitchell. I'm looking for Mitchell and or counsel Mitchell. Say something if you hear Austere Mitchell, I believe it is.
Good morning, sir. The name is Alistair Mitchell, and I am here. And I'm.
Thank you, Mr. Mitchell. Good morning to you, sir.
Good morning.
All right. So I see that you filed an answer to the complaint in this matter. And a part of your answer, you indicated that you don't have any information about this debt, that this is not an obligation that you entered into. You know that this has something to do with allegations of an account that is connected somehow, looks like it, to Art Van Furniture, sir. You have any information about this account?
No, I do not.
All right, Madam Counsel, you received the answer in this matter as well?
Your Honor, we did not, excuse me, we did not receive a copy of the defendant's answer, but the defendant and myself had an opportunity to speak this morning, and he did explain his answer as well as his position that he is not aware of this debt. So what we discussed is that I could send him the documents regarding the account, the underlying opening account information. And then once he reviews it, he'll either have his memory jogged and we can discuss resolution, or if he in fact feels it's fraud, he can file a fraud affidavit or a police report and we will investigate that. Given that we need to exchange that type of information, the parties would request an adjournment of today's settlement conference to allow the exchange of the documentation.
All right, that does sound reasonable. That makes sense to you, Mr. Mitchell?
Yes, sir.
All right. Madam Counsel, you think that a 30-day window would be sufficient in this regard?
I think, well, frankly, it really depends on what the defendant's position is once he receives the documents. Obviously, if he receives them and he agrees with the account, we can get it resolved fairly quickly. However, if he needs additional time to file the fraud affidavit or the police report, send a copy to our office for us to investigate, then it would take longer. So just to be on the safe side, maybe 45 to 60 days.
Well, I think what I'm going to do is, so you're prepared to get the documents out to Mr. Mitchell right away. Is that correct?
That's correct, Your Honor. We have those documents in-house.
All right, so I'm going to go ahead and put it out 30 days. I'll review it at that time.
Okay.
We'll see where you guys are along the grid, and if that is something that can be resolved, and just where the parties are 30 days.
Sure.
So 30 days from now, that
June 22nd. You said 30 days?
Yes, ma'am.
You want June 22nd?
June 22nd, June 22nd, 2022. That's the closest I can give you, June 22nd. So I'll set it at 9:45 a.m. on that date, and both sides should come back in and I'll do a review. It'll indicate the matter is set for review, and then we can go over where the case is at that junction. All right. Mr. Mitchell, you will get a notice in the mail of that new date as well, sir.
Thank you so much.
All right, good day to the two of you.
You as well. Thank you, Your Honor.
You guys have a great day.
You as well. Take care, Mr. Mitchell.
You too. Bye-bye.
Bye-bye.
The court now calls case number 21-240690. This is Gail Reed versus Protector Window and Doors. Today is the time set for a review regarding this matter. I know that the parties were attempting to see if there is a way to resolve the matter. I did refer the matter at a previous time for mediation, and send it over for review. For the plaintiff in this matter, let me see, do I have Gail Reed or anyone representing Ms. Reed? Say something at this time.
Gail Reed is here.
All right, thank you, Ms. Reed, and good morning to you.
Good morning, Judge.
For Protector Windows and Doors, your appearance at this time, Counsel.
Michael Norman, P75844, appearing on behalf of Protector.
All right, thank you, Mr. Norman. Good morning to you as well, sir. I know the two of you have come before me before regarding this matter, and I know that there were some issues that you were not on the same page on, but there was some attempt to see if you could come together, come close on what your differences were. And counsel, just because you tend to be in court more than Ms. Reed, would you go ahead and update me on the status of things at this point?
Yes, Your Honor. We went to case evaluation on May 4th. There was an award issued, and our response deadline, I believe it's June 1st, regarding that award.
All right, and so everybody's still considering that award, and you'd like the full breadth of that time. Is that about the size of this?
Yes, Your Honor.
Ms. Reed,
Would you repeat that? Would you repeat that, Your Honor, what you just shared?
yeah, there's what's been brought to my attention is that there was a mediation or evaluation, and there was an award, and that the deadline for responding to that is June the 1st. And the parties are asking that they be given that full amount of time to respond one way or the other. So essentially what the court will be doing is setting a date after June the 1st, so the parties have the right to go ahead and make their decision as to what they're going to do by that. Understood, Ms. Reed?
Parties meaning the plaintiff and also the defendant. So if I was to accept the award, it doesn't mean that the defendant is submitting to that award. Is
Yeah.
that why we have to set another court date?
Right, unless the parties are able, unless the parties today are willing to come together and say what they're going to do. It sounds like what Mr. Norman is saying is that his client is still evaluating that award to make a decision as to what position they're going to take. And they have until June the 1st to do that, just as you do. And if they accept the reward and you don't accept it, then it's not effective. If you accept it and they don't accept it, it's not effective. But if both parties accept it, then that would be the end of the case. But the big issue now is that both of you have until June 1st to decide what you want to do. All right. And so my intention is to set this early in June, maybe June the 7th. So you guys come back to me and I'll know exactly where the case is at that point. If you've been able to resolve it, then good. If not, I'll set it for a trial date, and we'll get to the business of having a trial hearing on this. I'm hopeful that you'll get it resolved. If I can be of any assistance in that way, then let me know. It's always good when there's a third party involved that is taking a look at things and have granted some type of determination that could be helpful to resolve it. But again, if the court's engagement, then I'll address that on the next action date. So I'm looking, Madam Clerk, at the 7th of June, just to squeeze this in for that review. So June 7th, and I'm going to go ahead and set that for 9:45, June 7th. And that way we'll at least know that the parties have taken a position on the mediation determination. June 7th, 2022 at 9:45 a.m. And we'll review things at that time.
Thank you, Your Honor.
Thank you.
We're supposed to- All right, I'm looking now at case number 22-178-401. This is evidence in mutual physical therapy versus Michigan Miller's Mutual Insurance. Matter is before the court, set on for a hearing after the submission of an answer together with a jury demand regarding this matter, the set forth status conference. Your appearance for the plaintiff, please.
Yes, good morning, Your Honor. Connor Clardy, P4485, appearing on behalf of the plaintiff.
All right, thank you, Ms. Flority. Your P number, if you will, for the record, sir.
My P number, sir, is P84485.
All right, thank you, Ms. Corrigan.
Thank you, Your Honor.
For Michigan Miller Mutual, your appearance at this time, please.
Good morning, Your Honor. Ken Lupo, P number 65439 for defendant.
Thank you, Mr. Lupo, and good day to you as well, sir.
Good
All
day
right,
to
so
you.
it looks like we're at the starting line with regard to this matter. As the parties had an opportunity to talk about this, it looks like with the answer and the demand for jury, there was quite a few documents that were submitted with your answer in this matter, Mr. Lupo. Is that correct, sir?
Yes, Your Honor.
All right. So Mr. Clardy, have you, the two of you talked about this at all? Had any engagement on this matter?
I have not yet had an opportunity to speak with Mr. Lupo. I'm not sure if prior counsel had the opportunity. I'm not showing that she did in my records. I would certainly like to speak with Mr. Lupo.
All right, and I see that the claim in this matter pleads between $10,000 and $25,000 as damage. Is that correct, Ms. Clark?
That is accurate, Your Honor.
All right, so of course, my inclination is to set a calendar on this matter. I'm going to put the two of you in a breakout room to at least deal with the parameters that might be involved in this matter and see if there is a way forward at this point, recognizing that if there's not, the court's inclination would be to set a calendar on this matter to allow for some discovery, et cetera. So I'll give you a notification for a breakout room. My priority is with you, so go ahead and take a moment to talk and then come back in and we'll go forward from there.
Okay, thank you, Your Honor.
Yes, sir.
Thank you.
The court calls case number 03-13-8581. This is CFC Financial LLC. Looks like Stafford. Shufford, SHUFFORD appears. The matter is before the court on the following objections to a writ of garnishment. That garnishment is regarding the Michigan Department of Treasury. That garnishment relates also to a judgment that was entered in this case. I don't have a complete file. Just one moment. Nor do I have a register of action on this matter, but it looks like the judgment was entered sometime in 2003 and then renewed in 2013. Your appearance for CFC Financial, please. CFC Financial. Andrew Perry, counsel. All right, this matter is set on for, thank you, madam. All right, do I have Tony Schufert on this matter? Ms. Schufert? Regarding a person living on Winthrop Street. All right. Just one moment. All right. So the record should reflect that the court did receive the objection to writ of garnishment and set it on for hearing on today's date at 10 o'clock a.m. It's now 10:18. Neither party has appeared. The objecting party has not made an appearance in regard to this matter. Accordingly, the objection to the writ of garnishment will be denied. The record should reflect that on the objection form, there was not a category checked off providing any basis for the objection. The court would have to find the objections are invalid. Any fine sale will be released to the plaintiff aimed at satisfaction, at going towards satisfaction of the judge. Is so ordered at this time.
for sellers. Gonna be doing that one.
Oh, yeah. Gotcha. Is that next?
I think it's one after this, one, after Ashley. Two down, sellers.
Okay, gotcha. This is case number 08103-649. This is National Credit Corporation versus Ashley Thomas. The matter is before the court on the filing of objection to a writ of garnishment. The record should reflect in this matter that there was a judgment that was entered in this case on the 10th of March of 2008 for $1,335.50. The record should further reflect that that judgment was renewed on February the 7th of 2018 for the same amount. Your appearance at this time for National Credit Corporation.
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Thank you, Mr. Cox. Good morning to you, sir. All right, I'm looking now for Ashley Thomas. Ms. Thomas, if you're on the Zoom, please say something at this time.
Good morning, Your Honor. I am here.
All right, thank you, Ms. Thomas. Ms. Thomas, your filing of your objections to the writ of garnishment, it looks like it relates to SEIU, Michigan State Council. Is that the place where you work, ma'am?
Yes, sir. That is correct.
All right, and I see that in filing your writ of objection, your objections to the writ of garnishment, it says the writ was not properly issued or is otherwise invalid because of invalid address. So tell me what you're talking about there.
Yes, Your Honor. Just in all honesty, I never heard about this matter or received anything or even knew about this until March 10th when my job brought it to me and told me that I was being garnished and that they had to cooperate. So at that time, I didn't know who the company was. I didn't know why or what was going on. So when I finally got through and I was told what this garnishment was for, I was still a little confused because I was told that it was a garnishment for a gym membership from back in 2008. And so I've never stepped foot in that gym. I never worked out in there. When I went in there, I was told that it was for a 7-day trial, not a membership. So I never signed a contract for a membership, and that's what I'm told I'm being garnished for. So I was just a little bit confused because this was back in 2008, and at that time it was for a 7-day free trial, and I was told that I had to leave a card on file even to use the 7-day free trial, and that if I wanted to move forward, then I had to come back and sign a contract for the membership. That was never done. After they took money off my card, I proceeded to go back up to that place and let them know that I never signed up for a membership. That, we discussed this, that this wasn't supposed to happen like this. So before I left, they told me that I didn't have to worry about it, that I didn't have to worry about the 7-day trial. They didn't want me to have any associations with that gym. So I never worked out there, went back, had a membership. And I'm just now finding out about this here in 2022, that I was being charged for something that I never used. I was never signed up for a membership. It was a 7-day free trial that I was told that I was using. I had to put my card down to be able to use that. And from there, I'm hearing about a membership and then I'm being garnished. So, Your Honor, I was really just trying to figure out, where this is coming from. And since 2008, I've never received anything in the mail. I've never received any type of contact or anything until now when my job, said that I was being garnished and they had to abide by it. So,
the issues that you're raising would be issues that you would have to raise in the underlying case. This is a post-judgment motion. That's why those various categories that you saw on the objection form, your objections would generally have to fit into one of those categories. It sounds like you're attacking the underlying judgment, and the court rules do not allow you to do it that way. The documents that I have in front of me indicate that back in 2008, that you were served personally with the summons and complaint. There was an affidavit filed with the court back then in 2008. And then in 2018, the judge that was handling this case on both of those occasions at that time renewed the judgment. So this has been going on, as you know, now for some 14 years or so. And it starts out with you being, it starts out with there being an affidavit filed, personal service. Now, if you believe that in 2008, that you did not receive personal service or anything along those lines, you have to file an appropriate motion to try to attack the underlying judgment. I would indicate to you that over the years, there have been a number of different filings that have been made for creditor's exam. There's a notification that a subpoena was personally served back in 2017, et cetera, et cetera. The long and short of what I'm telling you is that as it relates to the underlying judgment, you cannot attack that at a post-judgment hearing. This is just about the writ. This is not about the judgment.
Oh, okay, Your Honor. I'm sorry. I wasn't aware and I didn't know that, or I honestly didn't understand what was going on, Your Honor. So I do apologize.
No, that's not a problem. I understand and can appreciate why you wouldn't understand that part of it, because that would be something that you have to do a little bit differently, because the rules don't allow you to go after the judgment. We're only dealing with the garnishment. All right, so let me ask you about the garnishment. Has any money been taken from you yet?
Your Honor, yes, I've been garnished 3 checks so far, and they're about to do one this Friday, and it's really financially inconvenience for me right now, especially in the state of me taking care of my grandmother. So it's kind of been rough when they first started. That's why, and I put in this writ of garnishment over a week ago, Your Honor, and I had to go down to the courtroom after a week to find out what was actually going on. So I didn't even know about this court date until 2 days prior to it. I didn't even get the paperwork in the mail saying that this court date was May 11th.
Let me stop you for a moment. You must talk for a living, because you sure talk too much. You probably need to go to law school so you can become a talker like the rest of us. But anyway, you're talking too much. That's why I had to stop you. So let me ask you, how much money is taken on each occasion?
About 470 something, about $470 something, Your Honor.
Okay, so 470 has been approximately 470 has been taken 3 times, correct?
Yes, sir.
And then you said this week would be another garnishment, correct?
That's right, Your Honor.
So, counsel, let me ask Mr. Cox, how much money is owed on this judgment? Because the judgment was only $1,300. It looks like if they've garnished 3 times, that would be in the neighborhood of $1,400 now. Go ahead, sir.
Yeah, Judge. So we've received 2 withholdings of $435 each. I don't know why there's a discrepancy between what Mr. Thomas is representing and what we've gotten, but on April 25th, we got $435. On May 5th, we got $435. Previously, we did receive a disclosure indicating the defendant is paid bi-weekly. So we know those things. There could be a check that we got yesterday or this morning or some such thing where we can then, be catching up to where the numbers are in his representations. Judge, in terms of the balance, the total balance we still show as being $2,573.13, of which $609.25 seems to be the principal. So, there's a significant amount of interest, which also means there's probably a significant amount of wiggle room relative to resolution. Because I would think at some point here, we could resolve this if a lump sum offer could be made. My client's typically agreeable to waiving a lot of that back interest because, it's just a product of the case having sat around for 14 years. But that's where we stand with regards to those questions.
So the $2,500 balance that you're showing, is that after the $970 that you collected?
Yes, Your Honor. That's what we're showing.
Your Honor, can I say something? I heard Mr. Cox say that they've only. Okay, I'm sorry.
So if, well, I'm going to let the 2 of you talk. And here's what I'm thinking, that he has one other deduction that's already been taken that hasn't arrived at your office yet. And he indicates that this week they're going to be taking a 4th one. So that would mean that likely $970 additional dollars are coming to your firm regarding this matter. And here's my question about it, is whether or not that additional 970 would resolve this case. You don't have to answer that. I'm going to put the two of you in a breakout room, Mr. Thomas with Mr. Cox, to see what might resolve this case. In other words, $970 have already been taken towards us. There seems to be a balance of about 2,500. A lot of that is interest. You got a third payment that has been taken out that hasn't arrived at Mr. Cox's office, and then one coming out this week. That would mean an additional 970. The total amount would be $1,940 of those four payments will be $1,940. The question becomes, would that resolve this case? And if not, what will resolve this case? So I'm going to give you all a chance to just kind of talk about that in light of those perimeters. I recommend resolving it at that amount, but I can't control that. I'm going to give the parties a chance to talk about it and see if that might make it. So Mr. Cox, you're receiving a notification for breakout room 2, and I'm sending a notification to you as well, Mr. Thomas, so that you can speak with Mr. Cox directly. You're close enough to getting this resolved, and that's why I think that this is probably a good way to try to see if you can get on the same page. There's the notification, and I await your return to the Zoom.
Thank you, Your Honor.
Thank you,
And
Judge. How are we
this
doing?
is-
Thank you.
I'm a ma'am too. Thank you, you all.
I'm sorry, ma'am. Please forgive me.
Thank you.
I'm so sorry. All right, and I'm back on the record regarding the suffix 8401. That's evidence versus Michigan Miller Mutual. Thank you, gentlemen, for your patience and opportunity to engage in the ultimate act of collegiality, and that is to discuss possible resolutions. All right. So somebody go ahead and update me if you will.
Yes, Your Honor. So we did discuss the case and discuss that what happened here with this one is that there was a utilization review, and there was a determination that there was too much therapy, I guess, for lack of a better term, was provided past a certain date, and that's why it wasn't paid. And so counsel, we had the discussion of perhaps getting 90 days of discovery and continue during that time to exchange any documents and try to resolve that issue.
That is accurate, Your Honor. I think because of the utilization review, it's kind of thrown a wrench, proverbial wrench in the case, so to speak. But I think that with the 90 days of discovery, and if once Brother Counsel forwards documentation to me, I think that we'll be able to resolve this very quickly.
All right, makes sense to me. Everything except the 90 days. I'd like to take a look at this just beyond 60 days. So I'm going to go ahead and set it on 60-day calendar, and I'm going to bring it back on the
July. So this is July the 7th.
That's fine.
Oh, okay. You want some time? So what about the 12th?
No, that's all. It's a little bit later.
Later, so we can go on the 26th, July 26th.
Yeah.
Okay, great.
July 26th, that almost gives you the target date. July 26th, 2022 is going to be the next action date. That's going to be at 9:30 a.m. You'll get a scheduling order from me allowing open discovery during that period of time and up to and through that date of July the 26th. Also, the order that I'm going to issue will allow for you to file motions and set motions for hearing on that date as well. The only requirement is that you make sure that you give the other side at least 10 days to respond to the motion that you might file. In other words, if you file a motion that's positive or otherwise, you could set it for hearing on July the 26th at 9:30 a.m. so long as you give the other side at least 10 days opportunity to respond to your motion prior to the hearing date. That information will be contained in paragraph 6 of the scheduling order. All other matters I'll address on the next action date. To the extent that you need additional discovery upon your return, this court is open to such opportunities so long as the parties have exhausted their opportunities during the past 60 days. And a hint to the wise is sufficient. Obviously, if you have been working on the file and you need some more time, then that's an easy thing to get. If you've not been working on the file and you need more time, that's a little bit more difficult to get. So go ahead and do what you have to do over the the period from now through the 26th. If you desire to file a motion that arises during that period of time, go ahead and file it. I'll hear it on the 26th. Just make sure you let the other party know at least 10 days before the hearing and schedule it for that date. All right. I do wish you well, gentlemen. You'll get a copy of the order in the mail shortly with the information that we've just gone over. Good day to you.
Thank you. Thank you, Your Honor.
Thank you, Judge. Appreciate it.
Thank you, Ken.
Thanks, Connor.
I'm calling now for Capital One versus Amitha Sellers. The case number is 18-154261. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect regarding this matter that a judgment was entered in this case on the 29th of June 2018. That judgment amount is $2,228.66. The record should reflect that regarding the objections to the writ of garnishment, it's noted on the paragraph F. It says, I have a motion for installment and still getting garnishments as of 4/28/22. I am looking further in the file, and I do see where the court did receive a petition for installment payments. And in fact, just recently, I did grant installment payments, but then I noticed that there was the objection to garnishment. And so, well, in fact, I issued the installment order on May the 2nd, allowing for payments to be made beginning the 3rd of June of 2022. That would not have affected the objections to the writ of garnishment because that was pending a hearing on today's date. All right, your appearance for Capital One, please.
Good morning, Your Honor. Sandra Francis on behalf of plaintiff P74229.
All right, thank you, Ms. Francis, and good morning to you. Ms. Sellers, are you there? Say good morning to me.
Good morning, I'm here.
All right, good day to you, ma'am. I've gone over the nature of the objections that you filed with the court. It looks like your objections came right on the heels of you having filed your motion for installment payments. Did you get a copy of my order granting the installment payments, ma'am?
No, I've changed my address with the 36th District Court multiple times, but it's still not getting sent to me.
All right, well, the address that it would have been sent to would be at West 8 Mile Road, apartment 315. Is that a current address?
Oh, yes, that's the address I just changed it to for the second time. I did, when I went out to the 36th District Court, they did give me a copy of it. So I do have it. It's not getting it mailed to me.
All right, that's why you wouldn't have gotten it mailed. You
Okay.
came here, they gave you a copy, right?
Okay, yes.
So, Madam Counsel, did you know that I granted an installment order on the 2nd of May? I'm sure you hadn't received a copy of that.
No, Judge, we only received the motion on May 4th.
All right. So I did set it for $80 a month commencing on the 3rd of June. I do realize that there is a garnishment that is outstanding. Now, let's see. Now, ma'am, do you work for the state of Michigan?
Yes, I work for the state of Michigan, and they garnished my income taxes and my wages since March. So I'm on my 5th payment.
Okay.
For $455 every 2 weeks.
All right, got you. All right, so $425 have been taken how many times?
$455.91 every 2 weeks. I have talked to them and they told me I only owe $1,600 left.
Let me stop you. Okay, you have to listen to my question, okay? I don't care what you told them and all that kind of stuff. We try to get to the numbers now, okay? You said 455.91. How many times has that been taken from you? Is that the total, or that's been taken more?
No, that is not the total. 455 has been taken, I think, as of the 5th payment is coming out with this payment next week.
So 5 times 455, correct, ma'am?
Yeah.
Okay, All right, so is the amount the same amount on each time that it's been taken out for these 4 times? I know the 5th would be this Friday, but these 4 times has been that same amount, correct?
Yes, I believe so.
Okay. All right, so it looks like you will have already paid on this judgment, let's see, $1,820, $1,823 and something. That would be with the 4 payments, and then if a 5th payment comes up, that would be $2,278, $2,279.
Plus the 401 from income taxes.
What you say now? Say it again.
They also received the $401 from income taxes.
101.
$401.
I got you. That would bring it to 2680. All right, now, Madam Counsel, you know my question now. How much is the judgment?
Your Honor, on this account, we've received a total to date of $822.48. The total amount outstanding is $1,576.33. And just to clarify, the defendant is objecting to her $76.33.
And I know the defendant is objecting to the third party withholding, so it looks like that has to do with the state income tax, correct?
Yes, yes.
But it seems to me that she's indicating they've already intercepted that. You have not received that yet, correct?
No, we have not received any additional funds than what I stated.
Got it. Okay, so it looks like so after the 822, you're showing 1,500 that would still be remaining, correct? 1,576.30, correct?
Sorry, Judge.
Oh, yeah, you're showing $1,576.33 after the application of the 822.48, correct?
Yes, Your Honor.
Okay. So it looks like let's just do. I'm doing what they. I'm doing
Sorry, Judge. I just want to indicate something. It appears that the defendant has other accounts with our firm. So it is very possible that she may be confusing accounts. I'm just reviewing the notes here, and it may be that these funds are being garnished for another account.
All right. Do you have other garnishments, Ms. Sellers?
I don't. I have a payment plan. The garnishment from my job, they told me that it was this case. She sent it to me. She told me it was the one that ended in 6-1, and I do have that form. So it's this case with the garnishment for my job, my periodic. I work for the state of Michigan and the state of Michigan for taxes. So it's coming from the same place.
Got it. Yeah, I just want to be sure about that because obviously, you know, I'm trying to see if we get to a conclusion here, and if there's something in the mix, then anything that we do here is not, you know, it's not going to be meaningful because of the other stuff. So just give me a moment.
Okay.
To take what's been indicated so far. Just one moment. I guess what this is coming to, Ms. Francis, is that if the items that Ms. Sellers is indicating, noting that the income tax amount has not been turned over yet.
It has, Judge.
Oh, you have received it?
Yes, we received the income tax garnishment funds for $401 on or about May 2nd. So those have been applied to the account. So if what the defendant is indicating is in fact true, and we are to receive funds on this account, anything in excess would be returned.
Right, and that's what, of course, that's what I'm getting at. It looks like the gross amounts that she has indicated would in fact satisfy the judge. That's what I'm trying to get. But she says that the total amount is 2680. You indicate that you received already $822 of that amount.
Yes, 820. We've received a total amount on it since the judgment was entered of $822.48. So those payments, we received the payment, as I indicated, of $401 on May 2nd from the income tax garnishment. And it looks like we received back on November 12th of 2021 from a wage garnishment, the total amount of $421.48. Those are the only two payments that we've received on this account.
All right.
So if we,
I'm sorry, Madam Counsel.
Oh, no.
Go ahead. All right, so Miss Sellers, the garnishment that you are making reference to, those are recent garnishments, correct?
Yes, yes, they are. After March 25th, I've been getting garnished.
After March 25th, okay.
March something.
So, and you've been, and to this Friday would make 4 times that you've been garnished since March.
Yes, I'm looking at writ of garnishment was issued on March 2nd. I'm sorry.
Okay. And, all right. Got it. Okay. And so, here's what I'm getting at then. So she would have, looks like none of these garnishments would have been applied to this account other than the tax guard.
Yeah.
That's already decided. So what she's indicating then that she would have for a pending fifth payment at $455.91. Is that correct, ma'am?
Yes, that is correct.
Because I think if these numbers are correct, the balance right now on the judgment is some 1576. And if she's got 455.91 times 4, before we even talk about Friday, times 4, then that's $1,823. So, ma'am, are you sure that those garnishments relate to this particular case?
Yes, I am sure. They haven't released it yet because they said they have to wait till after I go to court today. So she is still holding it.
Okay.
My payroll department.
All right. So here's what I would, because it seems like, you see, this is a bit confusing because the garnishment doesn't specify whether it's the income tax or whether it's the wages. And because you work for the state,
Yes.
Because you work for the state, it doesn't really specify which one is which. Therein lies the problem. Okay. So here's what's going to happen. What I'm going to do is I'm going to I'll release any garnishment payments that have been made already to the plaintiff to be applied towards the judgment. The garnished amounts already appear to be in the nature of $1,823.64. The balance on the judgment appears to be $1,576. So the plaintiff would be required to refund to you any overpayment.
Judge, Judge, may I object to that? The defendant indicated initially that she was objecting to the state tax refund. I would request the fact that we don't have any evidence of what's been withheld. So to avoid us having to come back to court, I would ask that the objections simply be, if the court wants to adjourn the objections, and then we will, once we receive those funds, a satisfaction of judgment and release will automatically be filed. We received the disclosure from the garnishee, and they are required to wait 28 days before sending us funds. So I would ask that the court simply adjourn the hearing to avoid any, in the event that we don't receive these funds from the employer, because we don't have any evidence about what's been withheld at this point.
Listen, if you don't receive the funds, then it's likely you will be back here. If you do receive the funds, I don't think you're interested in coming back. I know that you like to do it that way, but I'm smarter than that, so we're not going to do it that way. I think you end up at the same corner. And here's what's going to happen: the court is going to release whatever funds have been withheld to the plaintiff. Whatever funds have withheld to the plaintiff. And then I'm going to stop the garnishment. Now, Ms. Sellers, we will, if you give us an email address in a moment, we'll send something to you to take to your payroll so they can stop the garnishment for this week, so they take no more money out. Now, I'll set it over for a week or whatever to review whether or not they sent the money to Capital One Bank, because it looks like the only reason that they're holding this is under the garnishment that was issued relative to Capital One Bank. And when Capital One Bank receives the 1,800 or whatever, then they would give you a satisfaction and send you some money back. If for some reason something about that goes wrong, then obviously I'm going to set a date for review for this to come back. But I think that this is probably already worked out, because money has been withheld. It just has not been released. If for some reason they don't release it to Capital One Bank, then you'll be right back here. We'll figure out what went wrong. That's where this case is right now. It's
Okay.
It's kind of intuitive that that's about where the case is right now. So I'm going to sign an order releasing the withheld funds to the plaintiff and stopping or suspending, as the language will go, suspending the garnishment in this case. And if for some reason the funds in satisfaction are not tendered, then the suspension will be set aside and then the garnishment will continue in this case. But I'll release the garnishment, and ma'am, you'll want to chat. You know how to put information in the chat, Ms. Sellers?
Yes.
All right, if you'll put your information in the chat, I will send to you a copy of the order denying the objections, releasing the funds to the plaintiff, but also stopping or suspending the garnishment immediately, and so that they won't take money out of your check for this week. And then finally, a couple of weeks from now, I'm going to set a date so that you can come in and counsel can come in. I suspect that this will be resolved, but if it's not resolved, you can tell me what happened and what went wrong. Right?
And Your Honor, if we do receive the funds by that time, are we just to advise your clerk and not appear? Okay.
Absolutely. Yeah.
Okay, thank you.
That's the quickest, that's the geometric line, the straightest distance between 2 points, straight line. All right. So Ms. Sellers, make sure you chat at your email address so that we can get this out to you right away. And Madam Counsel is only stopping the garnishment after today, so that it doesn't affect this Friday. It's releasing all withheld funds to the plaintiff. That's what the order on the objections is going.
Okay, thank you, Judge.
Thank you.
Thank you. And the review date on this matter,
25th.
the 25th,
Yeah.
25th of May. That might be a little bit early, because sometimes they are a little slow about sending it out. What do you think, Ms. Francis? Maybe, we probably should go to June.
That's fine, Judge.
June 6th,
June 8th.
June 8th, June 8th. June 8th is going to be the return date, June 8th at 9:30. June 8th at 9:30.
Thank you, Judge.
All right, thank you. Thank you to the two of you, and I'll get this information out right away.
Thank you.
Thank you.
Ms. Sellers? Yes.
Mhm.
It's fine.
Okay.
We're back on the record regarding National versus Ashley Thomas. And that's the suffix 3649. Welcome back, Councilman Bent. Welcome back, Ms. Thomas. Mr. Cox, if you'll update me, sir, this time.
Yeah, Judge, the parties did reach a resolution in the breakout room. What was agreed upon was that plaintiff would accept a total of $1,740 in full settlement, and plaintiff is not concerned about how it reaches that total. So I think what we're going to do is that Ms. Thomas has represented there's already been 3 withholdings of that 435. 1740 would represent 4 withholdings of $435. So what we want to do is let the garnishment run basically one more pay period, which would, she says, would be this Thursday. That would get us to 1740, and then we would want to turn it off and we'll file a satisfaction of judgment. So we need to fashion, I think, an order that grants her objections in part and stops the garnishment after $1,740 has been, the total of $1,740 has been withheld pursuant to the writ by her employer.
Okay, so here's what I'm going to do. Ms. Thomas and counsel, my order on the objections is going to indicate that the objections are invalid, and I'll immediately release all withheld funds to the plaintiff, and I will suspend withholdings as of the 10th. Strike that, as of the as of the 13th of May. So no further withholdings after the 13th of May. That means this last withholding will be allowed, and the funds, including that last withholding, will be released to the plaintiff, and that will resolve the case. If there's an overpayment, then the plaintiff will adjust that based upon the amount agreed upon by the parties.
Yeah, and likewise, Judge, if for some reason the employer misreads the date as being the date of calculation of the payment as opposed to the date of the issuance of a check, then the defendant would need to pay an additional $435 out of pocket to get to 1740. So as I indicated before, we don't really care how it comes to us. So Ms. Thomas, if for some reason your employer doesn't take that 4th withholding, then you need to call our office and put it on a debit or credit card or issue us your own check. But as soon as we get to 1740, we'll deem the matter satisfied and file a document with the court called a satisfaction of judgment that will indicate to the world that this is resolved.
I understand.
All right, and I'm putting that in a document, and we'll get that right out to both sides. And Miss Thomas, if you could chat your email address, we'll email a copy of this document to you so you could take it to your employer. It will say that the garnishment stopped as of the 13th of May. That allows for that last garnishment to be taken. So it says it stops after the 13th.
Thank you so much.
All right. So if you'll chat your email address, we'll send that over to you now. And I wish you well. Obviously, if they, for some reason, don't take that last payment out, then you got to get a hold of Mr. Cox's office so that you can go ahead and pay that, because it won't be satisfied unless they withhold that last one. They should, but if they don't, then you'll have to make sure that you get that one.
Right. And Judge, I told her too, if, like Your Honor said, if for some reason they take a 5th withholding, to call me, our office will obviously refund that. But we would file a garnishment release or some satisfaction to make sure that we don't collect more than 1740.
All right. All right, that's resolved. You'll get a copy of the appropriate order from me right away. And I wish both sides well. Thank you, Mr. Cox. Thank you, Ms. Thomas. Good day.
Very good. Thank you, Judge. Have a good day.
Thank you very much.
Bye now.
court is on the record in case number 10-110313. This is Hirschberg Acceptance Corporation versus, last name is Yancey, Shanita Yancey. The matters report on the following objections to a writ of garnishment. This is in relationship to a judgment that was entered in this case on the 21st of July, 2010 for $1,212.43. That judgment was renewed on the 20th of July, 2020 for $1,212.43. The objection, I'll strike that the garnishment relates to Highgate Hotels. Your appearance for Hirschberg acceptance, please. Hirschberg acceptance, please. All right, do I have Shanita Yancey on the Zoom? Ms. Yancey, if you're on the Zoom, please say something at this time. I've reviewed the objections to the writ of garnishment regarding this matter where the defendant has not appeared, neither has the plaintiff appeared. The objection says the defendant did not receive the judgment, waited 45 minutes for the file, unable to retrieve a copy of the file. That is the basis for the objection. The court did give notice of a hearing on today's date set for 10 o'clock p.m. It's now 11:03. The defendant has not appeared. The objections do not seem to address the issue of whether or not there is a balance that is owed. For that reason, the court will deny the objections, find them invalid at this time, and immediately release all funds withheld to the plaintiff. So ordered at this time. All right, this is case number 167363. This is William Beaumont Hospital versus Alicia Kinser. The matter is before the court on the filing of objections to a writ of garnishment. This is in relationship to a judgment that was entered in this matter on the 21st, right? That on the 5th of April 2021. The total amount of the judgment is $2,956.87. The writ is asked to the third party withholding unit, Michigan Department of Treasury. I've read the objections to the writ of garnishment. All right, your appearance for William Beaumont Hospital. William Beaumont Hospital, anybody appearing for William Beaumont? All right, do I have Alicia Kinser on this Zoom?
Yes.
All right, thank you, Ms. Kinser. Ms. Kinser, I looked at the objections to the writ of garnishment, and under F, you checked, it says the address on file, I've never lived at that, or have knowledge of, I've never been served any paperwork at any time, and have no knowledge regarding this matter. Ma'am, that the nature of the objection there would not be an objection that the court could consider for purposes of the writ of garnishment. The writ of garnishment is a post-judgment matter, and under the rules, if you wish to attack the underlying judgment, you have to file the appropriate motion of paperwork to deal with that. In this case, what I have in the file is a proof of service regarding the underlying case, which indicates that the court officer process server indicated that they served one Alicia Kinser, I should indicate, on the 19th of February 2021, 10 o'clock a.m. at an address on Renford Street, 20201 Renford, a person 5'4", 120 pounds, etc. Black female, it looks like. That's the proof of service that was submitted, and that's what the judgment was based upon. To the extent that you believe that this is not you and that this is not your debt, your obligation, you certainly have the right to file motions to try and intercept this and to try and get that judgment set aside. As of
I
now,
thought,
no, you
sorry,
can't start talking.
sorry.
As of now, that judgment is in place, and that post judgment is based upon the fact that there is a judgment in place. You'd have to get that set aside. You'd have to file appropriate motions to do that. Go ahead, I'm listening to you, Ms. Kitzer.
I thought I filed it because they told me to file for a motion. When I filed my objection to garnishment, I filed my motion at the same time because I never received anything at any summons or anything. I didn't even know that I even had this court date going on until I went and received something from 36th District Court. And then even the address they have on file is not mine. I've never even lived at the address. I don't know how they even gave me a summons, but I've never lived there. So I did put that in there, and I did put an updated copy of my address, and I had it stamped because the address they had on file was incorrect.
All right, and I do see on further review of the, file that you did file a motion to set aside the default. I do see that in the document. Also see the document attached there to with the, looks like, one second. Yeah, I see the address on Renford as your address, at least as early as 2020. And you're saying now the address is on Riverfront.
Yes, because it says that it was William Beaumont Hospital versus, and then it puts 165 Freeport Edinburgh Road, Detroit, Michigan. And when I came in the court, they specified that this was the address that they summoned me at, which I never received or anything. And if it was at the Riverfront, I've never received it also. I've been living at the 100 Riverfront address.
All right. So let me ask you, ma'am, you have an indebtedness with William Beaumont Hospital?
I've been to William Beaumont, but I'm covered under Medicare. So I contact Medicare and they told me that it should have been covered everything. And I've been going through, I did get a copy of the discovery. So I was going to contact William Beaumont to see where is this coming from and things like that. But I haven't got to that point. I just received all this information and I just filed the motion for objection.
All right. So as it relates to the motion to set aside the default judgment in this matter, ma'am, I really don't see a reasonable basis for doing so where you have been forthcoming to the court that you did live at the Renford address. And there is an affidavit filed from a process server indicating that they served you at that address, personal service, and signed an affidavit to that effect.
The Redford address is my grandmother's address where I received my mail. I don't live there.
I put you on mute because the absolute wrong thing to do is to interrupt. Okay, you just that doesn't go anywhere. Okay, you know that I give you a chance to talk. I'm always going to give you a chance to talk, but you cannot interrupt there. You just can't. That goes all wrong. So don't interrupt me. There's no such thing as you not getting a chance to talk, but do not interrupt. You cannot do that. Okay, so you can push *6. You can push *6 to come off of mute. I did put you on mute. And the long and short of this is that there is an affidavit indicating that you were in fact served at that address, and you're asking me to override that more than a year and a half later. Let me ask you, how tall are you, ma'am?
I am 5'2½".
And let's see, what's your age?
I am 26.
Yeah, the items put on the description items put on the description sounds like they fit your description. That's all of those are the kind of things that the court have to look at. And that's not to suggest in any way that that you're being disingenuous. I'm not saying that at all. I'm saying that the document that I have is a document by a third party that says that they served the document at that address, and of course the descriptions seem to be someone that fits your description. In order for this to be overcome, those are the kind of things that the court has to look at. And then, of course, what else becomes significant is whether or not there is potentially an indebtedness that arose out of a visit to the hospital or whatever. All right, so let me ask you before I deal with all this. Let me ask you about the garnishment. This is related to your state income tax return. Is that correct, ma'am?
Yes.
All right. How much money are you expecting back from the state income tax?
I believe it was 1,200. But I had to mail my taxes in, so it's delayed.
Okay, got it. Just one more. All right, so here's what I'm going to do, ma'am. I'm going to allow the garnishment with the understanding that if you're able to overcome the issues of this judgment being issued against you, then the plaintiff would be required to return the income tax money to you. The second thing that I'm going to do is I'm going to set this matter over for an evidentiary hearing. I'm going to take your motion under advisement, the motion to set aside the default. I'm going to take that under advisement. I'm going to set an evidentiary hearing that will require that the person who served the documents be brought before the court and give testimony as to what exactly occurred. And if there is a basis to set the judgment aside, then the court will grant it. If there's not a basis to set it aside, I would not set the judgment aside. So we'll get to that point upon the hearing date that the court is going to set on this matter. And again, if I set the judgment aside, then any money that's been taken from you would have to be refunded to you. And so we'll deal with that on the next action date as well. All right.
Okay.
So,
June 22nd.
So June 22nd is going to be the hearing date on this. And we're going to send you something in the mail regarding the June 22nd date. And that's going to be at 9:45 a.m. You will have to be available on that date, and you'll have to be available on the device where you can show your face at that time as well. All right.
Okay. I'm at work. I'm sorry.
And that's one of the conveniences of doing it this way, is that you can be at work. I just give you a little bit of advance notice on the 22nd of what we'll need to do. And we're going to notify the other side regarding the evidentiary hearing. You'll get a order and you'll get a notification of the evidentiary hearing, and you'll get an order denying the objections on the writ. But understand that if the case is set aside, and any money held by Lynn Beaumont would have to be returned to you. You understand?
Okay. Yes. So I did have one question as far as the garnishment. Are they gonna garnish? So I'm a server, so I don't receive checks at all.
Well, do you work for the state?
No, I work. No, I don't work for the state of Michigan.
Okay. Yeah, I don't see it. They haven't garnished your wages. This is just an income tax garnish.
Okay. I didn't know if it was for like, I didn't know what it was for. I honestly just received this information in the mail, and I contacted 3 lawyers about it, and then they just told me to make sure when I come to court, I state the same things that I've already stated, that I haven't received it.
Yeah, as far as the garnishment is concerned, the only garnishment is issued was this garnishment against the state of Michigan for the state income tax return. If you get something, they'll find you that pages of it, that's something that and that shouldn't happen. That shouldn't happen, given that I'm setting a hearing date for June, so nothing else should happen before that time.
Okay.
All right, so we'll see you on that date, man. All the best to you. Okay.
Thank you.
Just one moment. This is asking for that is that.
Okay.
Up at the front is the objections. Okay. Thank you for your patience all, and Mr. Bailey, I was wondering where your file was, but I see it now. This is case number 21-169-423. This is Trump Rides Incorporated versus City of Detroit. The matter is before the court on the filing of general civil complaint. I do see the submission of the defendant's city answer. I also see an application for a default that was submitted on the looks like 16th of March. Also a default against defendant City of Detroit. All right, your appearance. Excuse me, your appearance for the plaintiff in this matter, please.
Yes, I apologize. Karen Clark for the plaintiff, P number 74604.
Calvert Bailey on behalf of defendant City of Detroit, P 42409.
All right, thank you, Ms. Clark. Thank you, Mr. Bailey, and good morning to both of you. We did make it before the noon hour. Thank you for your patience in this regard. So I see that matter has been joined by the submission of the city's answer. It looks like in the interim, there was an application for entry of a default in this matter. Madam Counsel, you received the city's answer at this time. Is that correct?
Yes, we did, Your Honor. I assume that those things probably crossed in the mail, or perhaps we're just not, so I don't think there's an issue as far as that goes.
All right, you're withdrawing the application for entry of default at this time. Is that correct?
Yes, Your Honor.
All Thank you. The court allows the withdrawal at this time on that issue. All right, have the two of you had an opportunity to talk to see how near or how far you may be regarding this matter?
No, we haven't, Your Honor.
No, I believe this is our little initial pretrial here.
Okay, all right. So my inclination is to set it on a schedule, probably a 60-day schedule. And you're probably going to need that before you could talk comprehensively, unless the parties feel that maybe you could drill down on it right now. What do you think, Mr. Betty? You need more time?
Yeah, that's fine, Your Honor. I think we need the time just to look at the file, look at their billings and,
All right, very well. So I will go ahead and set it on a 60-day schedule, allowing for open exchange for discovery during that period of time. And I'm going to go ahead and set the return date for July the 26th, 2020. That's going to be at 10 o'clock a.m. You certainly have the right to file motions regarding this matter if you wish to do so, and to set those motions for hearing on that return date of July the 26th. This kind of cuts down on the time that would normally be allowed for motion for summary disposition and other types of dispositive motions and non-dispositives. But under this court's order, you can file a motion and set it for hearing on the 26th, so long as you give the other party at least 10 days notice regarding your motion, and I will hear it on the 26th. Otherwise, I'll review this matter as a pretrial conference on that date, and we'll discuss and see where the case is at that.
That sounds good. And I apologize, Your Honor, just for my purposes. Was it 10 o'clock?
10 o'clock a.m., 7/26, 10 o'clock a.m.
Perfect. Thank you so much.
All right, thank you, Mr. Bailey.
thank you, Your Honor.
The court now calls case number 18-180039. This is Tyson Coop Elevator Corporation versus M&M 8 Mile Incorporated. The matter is before the court on a motion to reopen this matter. Record should reflect that a stipulated order of dismissal without prejudice was submitted to this court on September the 9th. It was entered by the court on September the 11th, 2019. The court did receive a motion, plaintiff's motion to reinstate the matter and set the matter on for hearing accordingly. Your appearance for the plaintiff regarding this matter.
Morning, Your Honor. Roy Scroy appearing on behalf of the plaintiff, the moving party.
All right, your P number, if you will, for the record, Mr. Scroy.
P28168.
All right, thank you, counsel. I'm looking for Brent Leader or someone representing M 8 Mile Road. I have not received a written response to the motion, and somebody timestamped this. This is crazy. It says March 14th, 2024. We know that's wrong. All right, so counsel, have you spoken with anybody on the other side of this?
Well, Your Honor, by way of short background, when we settled this case, and as the court can see attached to my motion, there was a rather detailed settlement agreement. Unfortunately, courtesy of the pandemic, this is a gentleman's club on 8 Mile that was shut down for an extended period of time, so we couldn't arrange an inspection. Finally, in August of last year, we did get in there and inspect. We submitted a report of, the copy of that inspection report and an estimate to repair to council. That was by letter dated November 3rd of 2021. I did have a subsequent call with Mr. Leader, who said he was going to check with his client. I never heard back. I followed up with an email in February of this year asking him, what are we going to do? Because the proposal was, at least what I made to him, let's just release the $7,000 in full settlement of this case and keep it closed. Never got a response. That's why finally had to file this motion. And as you can see, I suggested as a alternative relief that we simply allow or the court order disbursement of the $7,000 held in escrow and keep the case dismissed.
Yep, and that's kind of my inclination about it is that that is likely the most reasonable approach to this. But I know that in order for the court to take that action, there would have to be something in the nature of a reinstatement of the case. So I don't know why the other side is not here. We did send a notice to the defendant's council address in Waterford, Michigan. That notice went from the court on March the 17th, setting today's date. And counsel, you received that notice in the mail of today's hearing date. Is that correct, sir?
That's correct.
And so the other side has not appeared on this matter. Under the circumstances set forth on this record, I do know that the stipulation for dismissal was without prejudice, meaning that there was an intent on the part of the respective parties that if something did not occur as per their understanding that the case would have room to be reopened. On counsel's representations to the court and on the motion at this time, I will grant the petition to reopen this matter. Having reopened the case, I've heard counsel's request that a certain escrow funds, some $7,000 in this matter, be allowed as a curative in this case, and that upon the release of the $7,000, the case can be closed, so long as those funds are released to order released to the plaintiff in this matter. Is that your petition at this time, sir?
It is correct, Your Honor.
All right, the petition for release of the escrow funds in the amount of $7,000 will be granted at this time. Those funds will be released to the plaintiff. Court will sign an order consistent with the same. In that same order, the case will be ordered closed upon the release of the escrow funds to the plaintiff in the sole order of this matter. Counsel, let me give you an email address so that you can send that order to.
Certainly.
So I can sign off on it. That's Latifah, LATIFAH dot, last name is Hunter, at 3636 36 districtcourt.org.
Let me repeat that for you if I can, Your Honor. Latifah, LATIFAH dot Hunter at 36th.org.
That's correct.
Or is it 36 DC?
Yeah, 36 District Court.
Okay.
Spelled out. 36 districtcourt.org.
I will prepare and submit the order, Your Honor.
Thank you, sir.
Thank you.